So, welcome to today's podcast. We're here for round two. I have Alessandra Long with me again. We're here to follow our initial conversation. We had initial conversation just to give you a broad strokes around estate planning, some of the details around it, and who the key players were in your estate plan. So we covered that. If you haven't listened to that, I would highly encourage you to go back and listen to that and get a kind of the broad strokes and broad view of an estate plan. Today, what we're going to do is go into a little bit more detail around wills and trusts. There's a lot of things that you can do with this, but today what we really wanted to cover is just kind of the core basics, help you get grounded on it and understand what you might be getting into. So, Alessandra, thanks for joining me again today.
Thank you so much, Tom, for having me. I really enjoyed doing these educational pieces with you. It's always a pleasure. So thanks for inviting me again.
Absolutely, absolutely. And this is where it's great to have experts in certain areas to share kind of and demystify some of these things. I mean, we know this from prior conversations. Uh, a lot of people want to avoid these things. It's potentially a little scary, and who not everyone really wants to talk about dying, but that's just a fact of life. So we might as well just face it head on and get it done, right? So
Exactly.
let's start with the basics here because we've heard a lot of people have heard these things like a will, right? Everyone should have a will, I think, right? And this is where you will help. So let's go talk a little bit more about will. So what is a will really? And sort of what are some of the kind of key components of it?
Sure. Well, there are different types of wills. There's several different types of wills. I think that, basically it is a document that is a disposition of your assets once you pass away. A will doesn't take effect until you die. So you can change it at any point in time before you either have no capacity to change it, meaning, you are disabled mentally, in a period of time, or you pass away. That's when it becomes obviously irrevocable, right? So you can change it, you can amend it. The way of amending a will, we call it a codicil, which is a legal fancy name of doing an amendment. You can replace it completely. And there's lots of different types of wills. There's like, very simple wills where you say, okay, I give all my property to my spouse and then to my children, but have really nothing else in them other than maybe naming guardians or naming an executor, naming a trustee if needed. But, that's, the basics are really in it. And then there are wills that have trusts within the wills, which are called
Mm,
testamentary trusts, which we could talk about a little bit later. But those are those are important when you have minor children and you have that language incorporated into your will. Um, Also, and I can, tell you reasons why I don't think it's an ideal manner of drafting a will to have testamentary trusts when you have minors, because then it's overseen by the circuits court, by the probate court in your town, and the trustees have to, report to the court and file with the court and keep track of anything and everything spent on that minor until that minor then becomes a so
mm.
it's not an ideal situation. It's better than not having a will, for sure. Any will is better than not having a will. But you know there's also wills that are called pour over wills, and a pour over will pours over into a revocable living trust. So really the trust has the meat of the document and has all the dispositions and where you want your assets to go and what you want to be done with them and what the trustee should do if you should become incapacitated in some way or if you should pass away. And that's the more ideal way in most circumstances to do a will. Like I said, if there are rare circumstances where a simple will is just fine. And that would be somebody maybe who owns no real property, that doesn't have any minors, that every single thing they own passes by beneficiary. So,
Hmm.
when I mean by that, I mean if they have investment accounts or a savings account or a checking account and they've put a transfer on death on those accounts or named a beneficiary on those accounts, and they have nothing that's really going to go via disposition through the will, a simple will could be quite sufficient. So it just really matters on the individual and what their preferences are. And, worst case scenario, they have to go through the probate and administration process. The executor of the will have to do that. And that takes some time. And we'll talk about how that works a little later.
Yeah, absolutely. So what, and that's what it is. It's especially, and it's probably going to matter to your point with, where you are in your life and, whether you have kids or assets. But, for people starting off, they're younger, like when do people even, should you even start considering getting a will in place?
Well, I think you should consider getting a will in place. If you do have any assets to your name, right, that you don't want to go just purely to a beneficiary, right? But I think it's important, I think, you know, you could be an 18-year-old and set to inherit some assets, right, through a trust or through this or through that, that there may be a reason why you need a will. So that's why I think it's important for people to consult with their attorney or an attorney to see. But like, let's just say like a young college student just getting out of college, right,
Hmm.
and not attached, getting their first job, they may be able to, not have a will as long as they have everything, they name beneficiaries on any of their accounts. But the benefit of having a will, even at that stage, and a simple will is that, what if there are some retirement accounts that they have started and they didn't name beneficiaries, or they should pass away young and they have, debts and taxes that need to be taken care of and things like that. So rather than their parents having to go through probate and administration and be named an administrator, at least their will names an executor to take care of their effects and wind things up and get into their apartment. And even if they don't own the apartment, they rent the apartment. Your will make it simpler for your, next of kin to, go in and clear out the apartment and give the assets to whoever they want them to. And, it's just not great to, listen to what the government says, right? And die intestate, and, if you have parents still alive, then automatically your assets would go to your parents. But maybe, if you die even when you're young and you don't have a ton, maybe you don't want it to go to your parents. Maybe you want it to go to your siblings, or maybe you have nieces or nephews because you're the youngest of the children or something like that. And you want, your assets to go to them. It's really not that expensive to put even a simple will in place. So I think that, it's always best to put something simple in place, especially once you start making some income and you have like your own place.
Yeah, and that's the thing. I think there certainly is probably a plethora of misunderstandings and misconceptions around estate planning, and certainly wills. Like they're why do I have to go do this? I don't have anything in that, and it's expensive, right? And there are inexpensive ways to handle this, just like anything else. Like just like you're doing a tax return, right, or something, you can do it. But like even getting a simple will in place, it shouldn't be that costly, correct?
Right. Absolutely. And I mean, it just really depends. But then, you also have to remember that as your life changes, you will need to change those documents, because then if you own real estate and you have a will and it says, maybe, it has a blanket statement that says your real estate goes to so and so, right? However, that so and so is going to, the executor is going to have to go through, you know, the probate and administration process to get the real estate retitled into the
Hmm.
beneficiary's name. So, but it certainly makes it easier when you have a will in place, because then the will is then filed by your executor into the surrogate's court, and the surrogate's court will then monitor things and say, okay, you executor, you have to take care of all of this person's affairs and, pay all the expenses, pay all the debts, um, notify any of the beneficiaries and what they're going to be getting. And at the end, once all the debts and everything are taken care of, then you can disperse the proceeds. But they will dictate who those, beneficiaries are and what they get, which makes it a lot better than the government saying who gets it and, you know, having to determine who your family members are and have a family tree and all those types of things, which can be avoided by having a will.
Right. Yeah. And are there any kind of, just out of curiosity, any really unique circumstances that you've seen where, hey, this is why, it's so important to get a will. Like you don't even think twice about it, whether it's, having a disabled child or, coming from a second marriage, whatever the situation. Anything in particular that,
Well, those
really
are all
highlights why
Yeah,
wills
those
are
are
so
all
important?
very good reasons to have a will. I mean, if you have a second marriage, absolutely you should have a will. Most likely than not, you should have a trust, because you want to make sure that you take care of your current spouse, but you also want to make sure that you take care of your children if you have children from a first marriage, because a lot of times you will see second spouse inherit then everything, and then the second spouse will then leave it to their children and
Mm,
not take care of the other children. So it's super important that you have a will, or a will and a trust in place in certain circumstances. And especially if you have a special needs child. I mean, a special needs child, it brings a whole plethora of other things in place, and considerations that one needs to take care of and consider, because you want to make sure that you name who's taking care of that child and who's managing that child's money. And you may need a special needs trust in place,
mm,
or you may dictate from the will that a special needs trust is to be created out of the will if you don't want to create one separately while you are alive, right? So that way, your then trustee would step in and then have to create that trust once you pass away, and then manage those funds for that special needs child. So there are a lot of complications. I mean, one thing that I deal with, and sadly on a kind of almost regular basis, is when someone leaves a will. I've got two instances like this. Someone has a will, they then become divorced, right? They're divorced. There is a child, let's say one child of the marriage, right?
mhm.
And the one spouse didn't never change the will and names, a trustee in the will, but that child is still a minor. So there you still have the problem of you they never change their will, so the executor of the will is still the ex-wife or the ex-husband. So it brings a whole bunch of complications, right? And then the probate court or the surrogates court has to then name a guardian ad litem for this situation, because to manage the money, because it's not the mother, because the mother's the ex-wife. You see what I mean? So,
Yeah.
or the father is the ex-husband. So somebody to manage the money with regards to that minor child, as long as they're a minor. And the situation could have been avoided by updating the will or doing what's called the pour over will into the revocable trust. Whereas then the trustee then just steps in and takes over for the person who passed away, and they don't have to be it doesn't have to be overseen by the probate court, which brings costs and expenses and time and you know stuff that you don't want to deal with when you're dealing with your everyday life.
Yeah, no, I get it. No, and this is why it's. I heard a joke the other day, and it was you kind of live each day as if it was your last, because one day you're actually going to be right, and
Yeah.
you want to have the things planned out in the way that you want, and the way you're describing is like, what would you actually want to happen? And you need to, in some circumstances, really detail that so that, your wishes actually come true for what happens after you're not here. We don't often want to think about it, but the reality is that it will come one day. It's just you don't know when that will be, unfortunately.
Yeah.
Um,
Yeah. And, you're better off naming, an executor and a trustee and guardians, of course, that's most important, of your minor children. You want to be the one to decide who's taking care of your children, taking care of them personally on a day-to-day basis, taking care of the funds that are to care for them. And, you don't want anybody else making those decisions or arguing about who those people are going to be, worse
yeah,
yet, right? So, you want to make it, as it's hard enough when someone passes away and the grief involved. Let's not make it a sticky red tape situation that, which we all too often see because people think, well, I don't have that much money, but, they may have an insurance policy that's,
mm,
even a $200,000 insurance policy, a $100,000 insurance policy that's then going to a minor. Well, someone needs to manage that. You know, they may have a $2 million insurance policy that's going to a minor. So you want to make sure that you have the right people in place to take care of your child if something should happen to you or you and your spouse, you
absolutely,
know.
absolutely. So you did allude to trust through this already. So let me just shift gears with that because trust. What's that funny one? The trustafarians and stuff like this. Like you always think it's just trusts are associated with a lot of wealth. Well, we
Yeah.
know trust can provide tremendous value even if you don't have billions of dollars, right?
Yeah,
So can you walk us through some of the basics, like around like what's a trust and what are maybe some of the more common types and where they
sure.
might be used?
Yeah, I mean, the most common type of trust that's used is a revocable living trust because a revocable living trust is basically a will substitute, right? You still need to have a will, but the will is shorter and has less terms. And basically, what the will says, I leave everything to my such and such revocable living trust, right? So
Mm,
it pours over into the trust. The will still talk about guardianship. The will still name an executor. It will name trustees, but it will pour all of the assets into the revocable living trust, at least symbolically it will. You still have to fund that trust, but, and I'll talk a little bit more about what that means,
mm,
funding. But that is the best setup, especially if you have minor children and if you own any type of real estate. And in Connecticut in particular, I guess I should have said I do practice in New York and Connecticut, California, and DC, but I'm going to speak mostly from a Connecticut basis and a little bit from New York because we're mostly in the tri state area here. So, but in Connecticut, what people don't realize is that even if you own your home with your spouse or with a non-spouse, joint with rights of survivorship or in some kind of form of that way, you still have to go through probate to get clear title. You still have to do a small probate and administration, even if it's just for the house, to get clear title, which is something that when I started practicing in Connecticut, I did not know because in New York, you can just file a death certificate of the person who passed away if you own your home joint with right of
mm,
survivorship, right? Not tenants in common, but joint with rights of survivorship. So in Connecticut, you have to go through a probate proceeding and even a small probate proceeding in order to get clear title. And a lot of people don't realize that. A lot of married couples don't realize that. And it can easily be avoided by doing your estate documents in the manner of a pour over will into a revocable trust and putting your real estate into a revocable living trust, which you can still sell, you can still mortgage, you can still do whatever you want with it because you still own it. You just own it as the trustee.
mm,
So that's one big reason for doing a revocable living trust. Another reason is you manage any of the assets you put in the name of the trust. Yeah, you put in the name of the trust as the trustee of the trust. You don't you don't manage it individually. And that doesn't really change a whole heck of a lot, except make it a lot easier if you should pass away and your successor trustee has to step into your shoes. So also it keeps things private. Like wills, once wills are filed with the probate court, they are public. So anybody can see what your will says. Now, if there's a reason to be more private, you would want to have the pour over will into the revocable trust, because the revocable trust does not have to be filed with the probate court. So that's another reason. And clearly when you have minors, your trust, your revocable trust, which again can be changed at any point in time, you can do an amendment to it, you can do several amendments to it, you can revoke it, you can replace it with another one. You can set out in the revocable trust what ages you want your children to get money at, let's say. And if they want to get, principal at certain ages or just get interest at certain ages, and what manner you want them taken care of through the trust funds. So there's lots of reasons to do revocable living trusts, and those are some of them.
Yeah, and it's interesting. I sometimes take for granted the fact that because I work in this space and I hear about trust, like you, people always wonder, like, where did this even come from? The concept of having a trust. Why do we need trusts?
Yeah. I mean, I have to say I haven't done the history of where the concept actually came from, but it is actually quite brilliant. And the fact that there are so many different trusts out there, people do have to be careful, because there are revocable trusts and there are irrevocable trusts. And, some you retain all the power over your money and your assets, and some you don't. You are giving, basically relinquishing some of the power, or and putting things already in the beneficiaries, let's say, interest into the trust, which then can only be used for the beneficiary or the beneficiaries of
Mhm.
those trusts. And there's so many different types of trusts out there with all these acronyms. There's slats, there's, or this, there, that, there's grantor trust, there's charity trust, there's annuity trust, there's charitable trust, there's all different forms of irrevocable trust. There are, family irrevocable trusts. There's, generational trusts. So there's, lots of different trusts out there with lots of fancy names. I guess my biggest thing is, you need to sit down with your attorney and you need to see what your goals are and what your assets are, and come to terms with what is the best situation for you and for your family. And, some people will come to me and be like, oh, I heard about this such and such a trust and I think I need one. And I'm like, okay, well, let's evaluate your situation and see
Mhm.
if you do. If clearly you have an estate tax exemption issue and you are going to be over the estate tax exemption, then you may want to do some of these irrevocable trusts and irrevocable vehicles, or if you have a special needs child, or it's a second marriage and you want to, ensure, certain things. Um, there's many different reasons, or you have, children with creditor problems or addiction
Mm.
problems. So there are many different ways to draft trusts and many different types of trusts, but they're all not right for everybody. So, but, you know, they're, they can be simple and they can be extremely complicated.
Yeah, and
Um,
that's and to your point. It's really, what is it you're trying to achieve with this, right? Because you mentioned the revocable, and to that point, I'm certainly have heard about the irrevocable ones that maybe provide some asset protection, but then you lose a little bit of control to them, right? Because they're protected, and depending on what you're trying to achieve with it, that's why you do need to talk to an attorney about it, because depending if it's related to estate taxes or, to your point, like having assets to be able to support a disabled child, whatever the situation, they're all going to be unique. But the fact of the matter is, there's a lot of options depending on what it is you're trying to get done with your money after you're gone, right? That's really the heart of it. And so you mentioned, you alluded to it earlier, the funding of the trust. Can you talk a little bit more about that? What does that mean, and what does
sure.
that require to do?
Sure. By creating a trust just doesn't mean that it's, it's a document, right? And it may be attached to, you know, it's just a paper document until you actually fund it, right? So funding it means you actually change title to an asset into the name of your trust, or you make, that's really it, or you can make your trust the beneficiary of an
Mm,
asset, right? So as you know, you deal all the time with opening up accounts for people, managing accounts, naming beneficiaries, naming contingent beneficiaries. So, funding the trust is actually changing the title of certain assets into the name of the trust. That's the simplest way to put it. And so you can, if you own a home, you can change the title of your home, you know, through a real estate attorney, through your trust and estates attorney, along with the titling agency, and change the title of the home into the name of your trust, your revocable trust, or an irrevocable trust if you wish to do that. And there, that comes with its own set of complications, but there are reasons to do it. So, once you put it in the name of your trust, then it's funded. It's funded with the value of your house, right? You can also fund a trust with a money market account, right? So you have an investment account, regular old investment account with your financial advisor, and say you're the single owner of that account, right? You can change that account name into the name of your revocable trust. So then you're managing that account as the trustee of your trust, but your advisor will have the trust and the terms of the trust to show that the successor, and will know on the account that the successor trustee is so and so, whoever you've named that successor trustee to be. So if you become incapacitated, let's say, instead of using the power of attorney that you may have executed and having your agent for your power of attorney step in, your successor trustee, with regards to anything that is in the name of the trust, can step in and manage anything through,
mm.
through their title of successor trustee, right? So that's what I mean by funding the trust. Like, it doesn't automatically happen by, like, oh, I have this piece of paper and it's a trust, and now everything's all in the trust. No, that's not the way it works. We have to work together. The same thing with an insurance policy. An insurance policy is another thing. Like, there are irreve- there are certain insurance policies that maybe you want to name the trust, the revocable trust, as the beneficiary because you have minor children, right? So maybe you still want it to be to your spouse, right? But maybe you want the contingent beneficiary to be the revocable trust, or you want to put the first beneficiary, the revocable trust, because the revocable trust says everything goes to your spouse anyway, and then to your children, right? So that's, again, another way of funding the trust. Or you can take out an insurance policy in the name of your revocable trust, or in a irrevocable trust. So a lot of people buy insurance policies and put them into, or take them out in the name of, an irrevocable life insurance trust because they want to avoid taxes on that insurance money. So that's another option. So those are all forms of funding a trust.
Yeah, and I always, in my simple mind thinking of it, I always equate it to have the trust is kind of the vault, but you got to put things in it, right, before you pass, right? You
Yes.
can't, things don't
Yes.
just flow to it like you described. So there is effort. And, this is why it's so key to have advisors like Alessandra on your side to help, because what happens, things change over time, right? Our circumstances change, our assets change, and so it isn't an automatic thing. So you constantly have to
Right.
stay in communication with your attorney to help you through these things, because things will change and your life will change, and so your estate plan will change with it, right? And you need to create advisors like Alessandra to help, right?
Yeah.
So that's wonderful. So it's good. No, it's really helpful certainly from understanding the basics around wills and trusts. Now, I want to shift gears a little bit and sort of talk about, you mentioned this concept of probate, and it doesn't sound like a fun place. It's not like Disneyland or anything.
It's not
Um,
Disneyland.
it's not Disney. So it's probably not the happiest place on earth. But so what is probate? And, because I've heard so many negatives, I've never gone through it personally myself, but like, what is probate and what does it serve in terms of the legal system and transfer of
You
wealth?
know, it does get a very bad rap. Absolutely gets a bad rap. And all of us want to avoid it, right? So we do. I mean, it sounds scarier, I guess, than it is. But, the one of the main goals we should all have is to avoid our heirs having to go through probate, right?
Mm.
Because first of all, you have to hire the attorneys to do it. And not that us attorneys don't want more income, but we would like to avoid it in that way, right? So it's like anything. Like it will cost you more money to go through probate than it will to get your estate documents in place properly, right? So, and it's time and it's headache and it's fees to the court. Like you have to pay a certain amount of money to the court in court fees, depending upon how much your probate estate is worth. So I
Mm.
think most people would rather avoid paying the government fees, right? If they can, right? So, I mean, basically, probate is a process of closing your estate, which
Mm.
includes your assets and your debts of any individual upon death, right? So, the process is overseen by the probate court and the probate court system and the state's laws regarding probate. So, every state has different laws. Every probate court has different judges and clerks and require things that are different. Some are easier to deal with, some are difficult to deal with, some are backlogged for a year or two, some are just fine and they're not backlogged and they go through things seamlessly, and but overall, from beginning to end, the quickest probate I've seen is probably 15 months, right? So, and the longest I've individually dealt with is 4 years. And forget it, the COVID years. That was terrible. So, you really, it's the role of the executor who you name in your will or the administrator. If you did not have a will, then, the next of kin will have to go through the probate court and have to file a petition to then have an administrator named to then deal with closing up your estate, right? Paying all your debts and then giving the assets to who they should go to, right? So basically, the probate court, the basic steps, starts with an executor or administrator presents the will to the probate court in a courthouse in the town that the deceased lived in or owned property at the time, right? So that's not even taking into consideration if they own property in multiple states,
Hmm.
because then you might have to do probate in multiple states, right? Or multiple countries if they own property outside of the country. Okay, so the executive, but let's just keep it to one state. So the executive administrator has to fill out or their attorney. They have to hire an attorney to help them because most of the time it's not easy to do it on your own. And then they file the probate petition, which is lengthy. And then and that then gives notice to the heirs and the beneficiaries and the local community of a probate hearing. And then they have to, once they get fiduciary letters, either the executor or the administrator will get these documents that are called fiduciary letters. Then they can go to their financial institutions and say, I need to close up this account, and they have to open up an estate account and put whatever monies into the estate account. They need to pay the estate taxes and funeral expenses and any debts of the estate through any of the assets that they then have to go and collect, right? They have to collect the assets of the deceased individual and then transfer title to any of the property that the deceased individual owned
Mm.
to who it then goes to, right? If it goes to the estate, Then they may have to sell a piece of real estate and then take the money and the value of the estate and put it into the estate account. Maybe the will said that a particular home or piece of real property goes to a certain individual, then they will have to make sure that then they transfer it to that individual. And then, once all the you have to go through a series of filings. I don't know how many there are actually because each state is different, so I'm not going to give you a number, but you have to file inventories, a probate petition, financial reports, give notice to all the beneficiaries, have them sign waivers when they get their distributions. You have to then distribute all of the assets once all the debts are paid. And then you have to close the probate proceeding. And once it is complete and everything has been distributed. So it's not an easy process. And there are small probate proceedings that are a little bit more expedited, and then there are regular probate proceedings, and that depends upon how large the estate is. So that's a very long-winded way of answering your question.
No, but it shows you the complexity of it all, and I'm sure there's a rhyme or reason for it, but we also know things don't move like super lightning speed in anything these days in legal, right? I mean, you know better than me. And
Yeah,
so what this is causing, not only some costs, right? Because you have to pay for legal costs and pay for this process because more people got to get involved. But the bigger thing as I'm assessing it is that the money that could be used to benefit your beneficiaries get hung up, right? You can't use all
yes,
those monies, right? And to your point, like it could last for potentially years, depending on the situation. So the more complicated your estate really is, the more painful this process sounds and more costly. Is that an
yeah,
accurate statement?
yeah, no, it is. And, and sometimes, you know, I mean, sometimes beneficiaries are people who are fine financially, right? And they're fine. Da, da. And sometimes the beneficiaries are people that need that money right away, like as in young children. You know what
Hmm.
I mean? So, it behooves you to do the proper planning to avoid the probate situation so that your beneficiaries um, finances can be managed by someone you trust immediately, or relatively immediately, like within a couple weeks of your death or,
Yeah.
a month of your death, rather than 6 months or a year or something like that. So, and again, to avoid the fees involved for the government, the court, and excess legal fees that you wouldn't have had to pay out of the estate that could have been avoided. And sometimes, listen, as long as you want to take, like, I've had people say to me, it's okay. I don't mind that the house has to go through probate. Everything else is taken care of, blah, 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 blah. If, my heirs have to deal with the house, that's fine. At least they only have that one thing to deal with. And that's fine. You're making an educated decision to do that. But be educated about it and what the ramifications are of it. And if you have adult children and that's what you want to do in that instance, just make them aware of it, you know? So, and like I said, and the thing is you just never know, like what depending upon where you live, really depends upon, how good and easy the courts are to deal with, right? So,
Mm.
there some of them are very efficient and the clerks are great and the judges are great. And some are just very overwhelmed and overworked and backlogged and, that's just the way it is. So, and then like I said, with the ancillary, probate proceeding, if you have properties in multiple states, it really does behoove you to do a pour over will and a revocable trust and put those multiple properties into revocable trust so that your executor does not have to go through probate in two different states. That's very difficult.
Yeah, and I've heard, and I've certainly have experience with clients have had to go through this pain, and in a time that they just grieving for their family or friends and such, and them to deal with this kind of stuff, it just adds so much more pain and suffering to a situation that could be taken care of ahead of time, right? So I highly encourage people to get with their estate attorney and experts like Alessandra to map this thing out and get it sorted, because you can save so much money, not even just the money, but the pain and suffering that now gets sometimes put on family members and people you care
Yeah,
most with. And so
yeah,
you can ease that burden
yeah.
by taking these sorts of steps. So you can almost eliminate the probate process almost in its entirety. Is that true?
Yeah, you certainly could. You certainly could if and that is the goal. At least my goal with my clients, is to eliminate it 100% because it's hard enough when somebody passes away to then distribute to clean out their house. Like we're talking real life, like, oh my
Mm,
gosh, somebody has to clean out your entire home and all of your possessions and give them to who they have to go to, right? That's enough work in and of itself. And then gather all of your assets from every account that you have and disperse them to, the correct beneficiaries in the amounts that they are supposed to distribute them. And that takes enough time and effort. So the more that people can do when they're alive and they're healthy and they're not under any kind of distress, the better. Like I always even tell people, I'm not saying that the 30-year-olds should be doing this or the 40-year-olds should be doing this, but listen, when you get to a certain age in life, like maybe you should consider, do you want to be cremated? Do you want a burial? Do you want that written in your estate documents? Do you want to buy and prepay for everything? My older adults, I encourage them to prepay for their burial arrangements, because the last thing again the family wants to deal with is, oh wow, I owe the funeral home $10,000. You know what I mean? Like, and I have no access to the money.
yeah.
So I've got to take it out of my pocket first
Right.
and then reimburse myself. So these are the things that when somebody dies, you don't have to worry about because you're enough dealing with the grieving process, you know. So
Absolutely.
yeah, I
Absolutely.
mean,
Yeah. And that's the other thing. And you said it perfectly. Like, yeah, I think for the folks who I've come across and they worry about this because they haven't addressed it. Yeah, I think of it, yeah, it should be a concerning thing, but you have the ability to actually get ahead of it
exactly.
and plan it out to your point without the stress now. Just, and you think through it with the help of trusted advisors like Alessandra, like you can get the things in place that
Yeah,
you want. And it's, to me, it's like just a caring thing for your family. And so I'd
yeah,
highly encourage you to seek it out, regardless of where you are in your current situation, life, your jobs, your career. The reality is, like, you don't have to listen to the news for 10 minutes without hearing someone passing. That's a reality. And to do this for your family, I think, is a tremendous gift. And you just need good people like Alessandra to help you through it. So I'd highly encourage you to seek her out or your, say, attorney locally to help you in your state, right? Because they're all going to be unique state rules and things you might need to factor in. But so, Alessandra, this has been so great. This is helpful. Any last sort of thoughts around the concept of probate that you want to share before we conclude this episode?
I really think I think you really nailed it, with your summary, but I really would encourage everybody. The thing that I hear the most is I'm just so busy. I just have no time to deal, with, getting my estate documents in place. And, the reality is that if you have the right attorney, they can make it very easy on you. It's asking you questions, it's a couple of meetings, you can do things on Zoom. Mostly everything can be done on Zoom or electronically. For those, obviously I have older clients that maybe don't use computers and things like that, but for the majority of my clients, it is very, kind of seamless process. And I also say when you do it now, when you're healthy and you're fine, it's a lot easier to think about, to answer questions, to review the documents, sign the documents, And, and then you don't have to like really look at them for, 3 years, or whether you have a life event. So, I do recommend that then people kind of reevaluate things, and just look at them every 3 years to make sure they say what they're supposed to say and nothing has changed in your life, or if you've had a major life event. But I think the time that, you put in, no matter how busy we all are, I think it really needs to be a priority, because people don't think it's a priority until then it's too late and they're like, why didn't I ever do this? Or they have a parent or a sibling that dies, and then they were named an executor, and then they didn't, their parent or their sibling didn't have anything in order, you know, per se, right? Other than maybe a simple will, but their circumstances had changed over the years, and, they hadn't taken care of things. So I really, just encourage everyone to seek counsel on this topic, because I think it's time well spent when you're
Awesome.
not under distress.
That's right. Good head of it. Good head of it. Well, thank you
Sure.
again for sharing your expertise around this. And we're going to be doing a bunch more kind of coming forward here, like on different topics. So hopefully this was helpful, and we'll definitely put your contact information for people to reach out to you, get some consultation, and get this thing started. So thanks for joining me again today. Really appreciate it.
You're welcome, Tom. Thank you so much for having me. I appreciate it.
Thanks for joining me on this episode today. I really am grateful for you as listeners to the Perennial Pride podcast. I hope you're getting some tremendous value out of it, and hopefully pushing you along your journey to financial freedom. I put this podcast together really to help help you get more educated around your finances so that you feel empowered to live the life that you really want. And if you like the content that you heard today or watched, then I would encourage you to go to my website, perennialpride.com. There's tons of other content there. And you can access my book, Wealth Beyond the Numbers. You can buy it there on my website. It's a aggregation of a lot of great tips and tools I've learned to not only build my wealth in my accounts, but build wealth in my life and abundance and joy, and something that has a lot of my experiences in the journey that I've been on personally. Hopefully that can be also of value to you as you sort of move forward. So thanks again for being a Perennial Pride listener, and we'll see you on the next